On September 20th, the state of South Carolina is planning to execute Freddie Eugene Owens, and he will be the first person put to death in the state in over a decade. But now, in a flurry of last-minute filings, his defense attorneys are saying that prosecutors concealed a secret deal they made with a key witness in the trial that sent Owens to death row. My name is Ted Clifford. I'm the accountability reporter for the state newspaper, and I cover crime, corruption, and the death penalty in South Carolina. In 1999, Freddie Owens was sentenced to death for the murder of a gas station clerk and mother of three named Irene Graves. Owens was convicted of shooting and killing her during a robbery gone wrong with his accomplice, Stephen Golden, in Greenville, South Carolina. And Owens was convicted of shooting Graves when she couldn't open the safe. And right as his trial was about to start in 1999, Golden took a plea deal and agreed to testify against Owens. And on the stand, Golden testified that prosecutors had not promised him a lighter sentence or that they wouldn't seek the death penalty in exchange for his testimony. And this is also the plea deal that he signed ended up saying. Golden was sentenced to 28 years in prison. But now at the 11th hour, Golden has delivered a signed statement to the court saying that prosecutors actually made him a secret verbal promise that if he testified against Owens, they would not seek the death penalty or life in prison. And he was told not to disclose this, and this was backed up in a draft of an affidavit that his attorney wrote up back in 1999. Now, Owens' attorneys say that this false testimony was crucial in his conviction because there was no forensic evidence connecting Owen to the murder, and it made Golden, who was the only eyewitness, seem more credible. And now they're calling on the South Carolina Supreme Court to stay his execution until this issue can be properly litigated. For their part, the South Carolina Attorney General's office has said that this is immaterial, and they're arguing that this is just a delaying tactic by Owens' attorneys and saying that parts of this claim were already known to the court during previous appeals. And they've also downplayed the importance of Golden's testimony, saying that Owens was convicted on the strength of testimony from multiple witnesses, including his girlfriend and another accomplice in these robberies that night. Now, this is not the only issue to have come up. Owens' attorneys are also saying that a juror in the first trial saw that he was wearing an electric stun belt, which they say prejudiced his right to a fair trial, and they're also arguing the Department of Corrections has not done enough to prove that the drugs used in the lethal injection are safe. So now the South Carolina Supreme Court will have to rule on these issues quickly if the execution is to be carried out at 6 p.m. on September 20th. To keep up with this story, follow our coverage at the state newspaper.